Wisconsin versus Chandler Halderson, 21 CF 1568. Could I have the appearances, please?
The state appears by committee here, Bob.
Good morning, City Michael Colby appears in person. Chandler Halderson appears via Zoom. Judge, prior to going on the record, I was able to speak with Chandler. He can hear me, he can see us, and I can see and hear him.
And is there any problem from his perspective if we proceed in this fashion rather than in person?
Judge, I did not do a colloquy with Chandler on that particular issue. I have no objection if you want to.
Mr. Halderson, with the understanding that we're not taking testimony or presenting evidence at this hearing, which does raise the limitations on being in person or by video somewhat under the statutes, may we proceed with this hearing with your appearance by video with your waiver and consent?
Yeah.
Has anyone forced or threatened you in any way or promised you anything to get you to waive your right to be present in person?
No.
And have you had enough time to think about making that decision prior to my questioning you here?
I have.
Thank you. I'm satisfied that Mr. Halderson is voluntarily waiving his statutory right to be in person. And in fact, I made sure that we could do a video appearance here because of the disruptive nature at times of transport from institutions to the jail, etc. We are here on the court's own motion, in essence. As I discussed or described to the attorneys in a letter on April 11th, I had a trial the week prior where attorney Amanda Reek, defending an individual charged with mutilating a corpse under subsection 1 of 940.11 and hiding a corpse under subsection 2 of that same statute, had, through a very roundabout way, discovered that those two statutes very specifically are identified by the Wisconsin State Legislature as a lesser included of each other, specifically hiding being a lesser included charge of mutilating. The manner in which that was brought to my attention was through research Attorney Reek was performing in a case where those were the two charges, where there had been discussion about a lesser included of an attempt, and she actually located a case, which is State v. Davison, 263 with 2nd 145, where the Wisconsin Supreme Court recognized that when examining the statute for lesser included offenses, the legislature was at times very specific and listed subsection 7 of that statute, noting that the hiding charge is by statute a lesser included of the mutilating charge. This was frankly something that the attorneys and myself in that case had not observed and obviously had not been raised in Mr. Halderson's case. Mr. Halderson proceeded to trial on an amended information filed by the state on December 28, 2021. Count 3 of that amended information alleged a violation of 940.11 sub 1, mutilation. Count 4 of hiding under subsection 2. Count 7 and 8 identical charges. The first set related to Bart Halderson, the second set related to Krista Halderson. And as everyone is aware, those counts, as well as the other 6, actually 4 counts within the amended information, were tried to a jury, and the jury returned guilty verdicts on all 8 counts. When I learned that the statute addressing and recognizing included crimes and specifying that an actor may be convicted of either the crime charged or an included crime but not both, and then the legislature specified hiding is a lesser included of mutilating, I became concerned that there may have been in this trial error of a nature that needed to be addressed based upon the legislature's determination and the absence of anyone at the trial recognizing that fact. I note that there was certainly a great deal of testimony regarding what the state presented as events occurring over a number of days. The charging document itself alleged that the actions at issue occurred on and or between July 1 and July 8 of 2021, and the evidence demonstrated to a jury a course of conduct which they believe satisfied the elements of all of the counts within the amended information. But the legislature has taken a view which I think needs to be addressed by the court at this time in order to avoid any error that would be obvious and plain and detrimental to Mr. Halderson's rights, given the statutory provision that I have discussed. I raised this with counsel and requested that we could do a hearing on this so that everyone would have advance notice of the issue and would be prepared for today. And I appreciate that Attorney Gerhoff and Attorney Covey are here. And I understand Attorney Covey needed some time to speak with his client, and you've had enough time to do that, Attorney Covey?
Yes, sir. I'm comfortable going forward.
Thank you. Then let me invite Attorney Covey. What's your position as to the question here, unless you wish to have the state go first? I'll recognize also for the record that I'm aware that yesterday on the 18th you filed and the Court of Appeals granted a motion, in essence, withdrawing the no merit appeal report that you had, I may have said that wrong, no merit report that you had filed in the appellate action and reopening that examination essentially for yourself as post-conviction counsel. So would you be comfortable stating your position first on the record here?
Absolutely, Judge. I will request a chance to respond to the legal arguments that Attorney Gerhoff made. Judge, just to correct the record on a couple things procedurally, this is inside baseball. I have to do this to protect my client's right. I did recently file a no merit notice of appeal. I had not filed a report for that. That report would likely have been filed over the summertime. Because Amanda Reek, to her credit, and she's a phenomenal attorney, discovered this issue in the course of her trial. Since there was an issue of merit, I was obligated to withdraw that no merit notice of appeal. And so from the point of view of the appellate situation, we're kind of at stage 0 again. I want to make it clear that this hearing is from the court's own motion. I was appointed to file either a post-conviction motion or notice of appeal under Rule 80930. There's a lot of case law that states, with some exceptions, that if I file a motion and or appeal, then I have to raise every single issue all at once, or else I take the risk of waiving any subsequent issues that we might want to litigate. I know that I won't state anything on the record, but I know that Mr. Halderson wants to litigate this case going forward as it applies to the other counts. So I'm certainly not going to object to vacating this. I believe that from what you suggested in your letter, that the statute is pretty clear that counts 4 and 8 should be vacated. But I just want to make it clear that this is from the court's own motion. Procedurally, it's as if the court was asking to amend the jail credits or some other kind of clerical issue on the judgment of conviction. So we will agree to that. I know the state has some thoughts about the legality of the request, but I just want to make a record that this is not a 80930 appeal, and that we reserve the right to go forward on any other issues that we deem have merit. Thank you.
Thank you. I understand exactly what you're stating. I appreciate that you took the steps in the Court of Appeals timely after I raised this, and the record should absolutely reflect that we're here today on my own volition, believing that there needs to be something done to address what was discovered very recently about the lesser included statute.
Hey, Judge. Well, obviously I was the prosecutor in that trial.
Correct.
And so just so the record clear, I did take the position in that trial and agreed that this statute 939-66 sub 7 was a statutory carve-out for a lesser, and the court is aware, during the course of that trial, I agreed that the instruction should be given as a lesser included, that we should, the greater charge was the mutilating, hiding the corpse was a lesser offense. So I have argued in front of this court, taking the position that is an appropriate interpretation of the law. I note a difference in this case. I think from the state's perspective that conviction on both the hiding and mutilating counts, because unlike the trial case we were in, where it was factually contemporaneous, here the factual evidence suggests that the mutilation and the hiding would have occurred at different times, different dates, and different locations, and therefore a conviction on both hiding and mutilation, as they relate to the political counts here, is legally permissible and appropriate. I also note that the charging document in this case and what the jury was asked to consider was a date range. So I am aware of that as a possible issue. The state believes a couple things. One, that ultimately this can be litigated whether or not the statutory interpretation is applicable to make a lesser in this circumstance or not. Functionally, it doesn't necessarily change what happens to Mr. Halderson. The court ordered those counts to be concurrent to the consecutive sentences while he's serving. So, because we all recognize absent of appeal on different grounds, it doesn't really change status for Mr. Halderson. I will also note that we have conferred with family, and quite frankly, I think that every time something comes up in court, it causes anxiety and stress, and I think that the family would like to have as much closure as it possibly can in the legal system. So having said that, I do think this is something that could be litigated. What I would propose to the court is that if the court wishes us to further brief this issue and set a briefing schedule, that's acceptable. If the court proposes to rule from the bench today, that is acceptable as well.
Judge, just to respond briefly to what Counsel Todd spoke about, certainly again, we're not going to object to you vacating this. If we do have to fight this, if you didn't want a briefing schedule, I would be happy to draft a brief on it. My view is that, almost by definition, the process of mutilating and hiding a corpse doesn't necessarily have to be something that occurs at exactly the same time, but it would still encompass one crime. Not every single crime occurs at a moment in time, but sometimes a single crime can occur over the course of several days or months. So my view is that if this was argued in brief, the ultimate decision would be that it would be vacated. But if we can avoid that process, and if the court were to vacate counts 4 and 8 today, I'm certainly not going to stand in the way.
I am very cognizant of the fact that revisiting the verdicts and the sentences in this case is disruptive for everyone, and appreciate what Attorney Gerhoff says regarding that factor, and it may as well, although Mr. Halderson is in the status of appealing and pursuing an appeal, it may as well be an impact for him. The court has the advantage of having listened to all the testimony throughout the trial and having an understanding of what it is the jury observed and heard, and the fact that the law does not require at trial the state to be specific about which act consisted of a mutilation for purposes of a verdict. The jury was not required to delineate exactly what they believed had occurred at this point or that point in time as far as either of these actions with regard to both victims, and the longer date range over which these crimes were alleged to have committed and, as found by the jury, were committed. I'm satisfied that when the legislature took the position that a hiding is a lesser included of a mutilating, that even though, as Attorney Cody says, those acts are almost necessarily always going to be separated by some time and some separate act, I think we are bound by the determination made by the legislature that the one is a lesser of the other, and that the language of the statute clearly specifies that there cannot be a conviction for both. The jury heard the evidence and returned verdicts on both counts as to each victim, so I have no hesitation in saying that the verdict that they reached on the greater charge, the mutilating the corpse charge, withstand scrutiny, and that the verdict on the hiding charge should not have been placed before them in the format of an equal charge, but only as a lesser included, were they to not come to a belief beyond a reasonable doubt that there had been a mutilation and a conviction appropriate on that count. And therefore, I think that to let both stand with the facts of this case, with the evidence which was presented and the charging periods and charging document, I think to let both stand, specific counts 4 and 8, would be committing plain error. Plain error is error so fundamental that a new trial or other relief must be granted, even though the action was not objected to at the time. That's from State v. Miller, which is 2012 West App 68. And that's precisely the situation I believe that I'm confronted with here, that there was plain error through this trial, and that other relief, short of a new trial, must be granted. Obviously, there was no objection at the time, so that fits the quote as well. There's no reason to do other than vacate these two specific convictions because of the nature of the convictions for counts 3 and 7, the evidence being, in essence, solid and supportive of that greater offense. And because the sentences here were concurrent, there's also no impact upon the overall sentence structure that the court imposed as to Mr. Halderson, and other than the court costs associated with those 4 counts, or 2 counts, excuse me, counts 4 and count 8, there's no other real impact in terms of the sentence or moving forward the nature of the other convictions. So I do believe at this time that the best course of action for this court is to, in essence, reopen and vacate the convictions on count 4 and count 8 of the amended information upon the basis that those counts should have only been presented to the jury as lesser included offenses for counts 3 and count 7, the jury having reached the verdict beyond a reasonable doubt as to counts 3 and 7, then they should not have been considering counts 4 and 8, and I will vacate those 2 convictions, order any court costs paid on those 2 counts to be refunded to whomever paid, and obviously vacate the sentence on those 2 counts as well. Is that a sufficient record for your purposes, Attorney Cole?
Judge, I'm very satisfied, thank you.
And I ask you first because you're the person carrying the ball as far as any post-conviction or appellate. Is that sufficient for the state's perspective?
Yes.
Very good. Is there anything else we need to take up here today?
Okay.
No, sir.
Thank you. Thanks to the institution for having Mr. Halderson available to us, and we'll stand adjourned. Would you like some time, or is your...
Judge, I set up a phone call with Mr. Halderson tomorrow, so I think we'll address any questions you might have.
Very good. Thank you.
Thank you.
We'll be adjourned.
News 3 Now is always on.
Get the Channel 3000 app, activate the push alerts, and we will send you breaking news, traffic, and weather alerts as it happens.
The Channel 3000 app. Get it now.
Powered by News 3 Now.